We are back on Morning Line. Thanks for joining us. Talking elder law questions you may have for attorney and nurse Barbara McGinnis. We have actually a caller that waited to the break, Barb. So we'll go to Dan. Dan, good morning. Hi, Dan.
Oh, hey.
Good morning to you, Dan. What's on your mind, buddy?
Well, we had an elder care attorney came to our senior citizens 2 or 3 years ago, and the understanding that I had was that it was going to cost $12,000 or $14,000 to be an elder care lawyer for my family. And I mean, I ain't got enough money to even to join, to allow for that. But is there some kind of a program, or is there some way that it can be adjusted? I mean, how do you determine?
Yeah, great question, and I try to touch on this whenever you come on. Lawyers deserve, obviously, to get paid for their work, and they are not always cheap, but you see the gamut. You probably have people with million-dollar estates that come to you where cost is not an issue, and you have others like him who may have means to pay something, but it's not that much. How can you help folks who are like, I don't have the money for a lawyer, or maybe they do, but it's certainly not $10,000.
Yeah.
How do you do it?
Well, one of the first things that I want to say is when someone calls our office, we do an intensive screening process to understand what their concern is. I would imagine almost every office does something similar to that to make sure that, one, you could be appropriately served. Two, if you're very concerned or if you're of very modest means, that you're referred to someplace like Tennessee Justice Center, depending on what you're, if it's a Medicaid or an elder abuse issue or something. Legal aid. There's always clinics. If someone needs powers of attorney and a will and they can't afford our fees, then we will refer them to what we know to be good providers that charge less. Part of the reason we charge a little more, and we're probably on the higher side. Please don't ask me how much. Is because of our representation over time. It's not just transaction, here's your documents, now go away. It's the fact that we have you for a prolonged period of time. It's the fact that we do Medicare counseling, and we have the care coordinators. It's the holistic representation that we provide that causes us to charge a little more. And the fact that we represent over time, we don't just produce documents and send you on your way. So we're unique in that sense, and it's not a good fit for every family. So every family needs an estate plan. It doesn't necessarily have to be done in our particular practice to be a good estate plan. So we do try to help folks find what they can afford and what they need. I've seen folks with absolutely zero money, and I'm just telling them where to download forms off the internet because they can't afford anything.
If they're just looking for a will or something like that, you point them in the direction.
If they have zero money, they probably don't need a will.
No, that's right.
But they probably do need powers of attorney. And the advance directive form, the standard advance directive form for healthcare decision making that meets statutory compliance in our state, can be found on the Tennessee.gov website. It's the state form. So I'd rather see someone with that may not be a perfect document, but it's a document that would help them make and have a person that could make healthcare decisions for them if they were in an emergency situation. It's something. It might be enough to keep them out of a conservatorship. It may, if not, at least they have picked their person that could be their conservator, and it's not just an unknown third party.
For those families who do then, though, come and decide they want to have the long-term relationship and have that estate set up, is that something where they pay you on a monthly basis, some type of fee, or is there an upfront retainer and then it just as it comes along, or is it just individual to the family?
I think, different law practices probably charge in different ways. Estate planning attorneys usually have a package deal that this is what you're going to get for X. Estate planning and elder law attorneys probably very rarely charge an hourly rate, only if it's a court proceeding where you have to charge an hourly rate. Like if we're doing conservatorship work or probate work, it is often an hourly rate that's submitted to the court for approval. But for Does it matter if you're looking at elder law practices or estate planning practices? They're probably a package deal like X for Y.
Gotcha. Okay. All right. And it can be tailored to the family depending on the size of your estate. Let's go next to Ed. Ed, good morning. Hi, Ed.
Good morning, Nick.
Good morning.
Yeah. I got a question that concerns probably everybody, and it has to do with money. We know people get along pretty good until it becomes, they may think they can go get a chance to get a little bit of money. And so I got mine. I only got 2 accounts. There's not much in there, just enough to keep me and the wife going. But anyway, I got it set up. If anything happens to me, she can automatically go draw the money out. We've got an insurance policy, and it goes to her, and of course the house. If I want our croak before the wife does, it's going to go to our daughter because this was her house before. This was her house. She grew up in it.
Okay.
Now I got some other things, but that's okay. The nickel and dime things to give to people is a memento but when it comes to money, and the lady there knows, and you've seen stories, you run stories on this too, Nick. The big fight comes on, especially if there's money and they think they're going to get something. And a lot of times it'll cost them more in lawyer fees to get that funds than it does to get the money. So would you please explain a good setup on this for the folks out here? Because let's face it, when they're talking about George Washington and Abraham Lincoln, hey folks.
Mm-hmm.
And with that, Nick,
thank you
kindly for your time, folks.
Thank you. Yeah, it's probably more touching about wills. We hit on that a bit earlier, but yeah, you're right. People can come out of the woodwork sometimes.
People do.
When there's a past.
And one of the more difficult scenarios is blended families or unblended families. Estranged children that come back after the death of someone looking for their share of the estate because they were blood. But one thing that he reminded me to talk about is it's not just your will, it's also how you hold title to assets. Because now he mentioned he has bank accounts set up for his wife at his death.
Okay.
And the house, and there was life insurance and the house. So all of those assets could pass without a will. If you think about how does he own title to those during his life, meaning the bank accounts, are they joint accounts between he and his wife, or are they just in his name and he's got a payable on death designation to the wife? The life insurance policy is going to have a beneficiary designation. So is that the wife and then the daughter? Is it the wife and the daughter? If you name an entity, a person or a trust to be the beneficiary, or do you just name your estate? Now that's kind of like a default, and it's not necessarily something I recommend. It has to be like a particular fit for your goals before I would say that's a good idea. But so bank accounts can be held jointly, or you could have a payable on death.
Okay. Life
insurance policies would have a designation, a primary and a secondary, primary or contingent. And the house could also be owned jointly with a right of survivorship. Spouses usually would own property with it's a special thing in Tennessee called tenants by the entirety, but it's a right of survivorship. Or you could have the house with a life estate. So I have a house, I give it to my child, but I retain a life estate, meaning I have a lifetime right to live here. And also a lifetime right to maintain it and pay for the upkeep. But when I pass away, it's going to, the title vests to my child, the person I've named, with the remainder interest. All of that happens free of probate. So it's regardless of what your will would say. So you have to make sure they match. If you put something in your will, I want all of my assets to go to my grandchildren in your will, but your beneficiary designation is to your one son in California, then that, you know what I'm saying? They have to match.
Yeah.
So it's a little bit more detailed and, I don't know, thoughtful than just creating a will.
Put your thought into it then. It looks like Ed at least has a line on it in regards to his wife. Yeah. Got more calls coming in. Let's go next to Dot. Dot, good morning. Hi, Dot.
Oh, hi.
Hi, how can we help you?
I have a question about wills.
Okay.
I'm 86 years old. I'm a widow. I have 4 children who are very close, and I've always assumed that when I go, they will get for anything that I have. Everything's going to go to them. But I have friends who keep saying, no, you need a will. If you don't have a will, the state will come in and take everything. What I need to know is, what does that mean, the state will come in and take everything?
Okay.
All right.
So assuming that we're not talking about any kind of estate recovery or TennCare recovery, that Dot, widowed with 4 children.
Yeah.
She's talking about laws of intestate succession. So intestate means somebody that dies without a will.
Okay.
Succession means, you know, what happens after, right? So the state has this set of laws that directs how your assets will be distributed if you don't have a will or a trust or some sort of mechanism for distributing assets. So if you're not married, but you have children, your assets would pass to your children in equal shares.
Without a will.
Without
just
a will.
the way it is.
You would probate. You would have to probate.
Meaning that the court would have to just, is that a real hard thing for her to deal with?
No, it's not a real hard thing. So
okay, so just let's be real clear right up front. The state does not come and take your money. That's not going to happen. That's wrong. I mean, the state doesn't. Now, the state will require something like probate, which is probably going to cost a little bit out of the estate to pay for the process.
Yeah,
but they're not there to take it if you don't have the will. So the way the law is set up is it will go to her 4 children, but you'll have to go through probates.
But what if she wasn't, I mean, she's widowed.
Yeah.
And she didn't have children.
Okay.
And at 86, her parents are passed away. Her grandparents are passed away. Does she have brothers and sisters? So this is where you have to know what would happen to her assets if she did die without a will. So she's not married. We're pretending she didn't have children. Her parents are passed. Her grandparents are passed. It would go to her brothers and sisters.
Okay.
If she didn't have brothers and sisters, she's an only child like I am. So no spouse, no children, no parents, no grandparents, no children. Then we're starting to go out to cousins. And it's just if we can't find anybody, the state is the last point of distribution. I mean, if there is nobody that you're related to can be found, it would go to the state.
Who does the searching for the cousins if they're clueless that she even died?
Yeah.
Who does? I mean, I'm just saying, who gets paid to go search for relatives?
So it probably would wind up in that unclaimed property on those, and it would sit there for a while.
Would you recommend her, even though you've just said that she does have these 4 siblings, that she said are close, go ahead and spell it out in a will, or if, as you say, everything's okay, just let it be?
I think she deserves a consult to talk about what kind of assets does she have and how are each one of those things titled. Just because if she was hit by a truck tomorrow and she dies without a will, her children would receive her assets eventually after they went through an intestate probate. But isn't there an easier way to get that done?
Yeah.
Yes, there might be.
Spell it out.
So that's what I would talk about with her.
And the assets, too, a good point here is it's not just always like just cash. I mean, she may have in mind that there's a piece of jewelry that one of her daughters specifically would really like.
Absolutely.
And there may be something that you might want to write in, and to be very fair, of course, to all of them, and they wouldn't fight over it, but you could specify that, oh yeah, well, this was her son's favorite chair or whatever. He can have that. The rest of it you guys divvy up yourself,
right.
But she could be specific on things if she wanted to.
She could.
Okay.
And that personal property is often what people fight over. It's money is is a math equation.
And that's easy to accept, quarters to each of you. But these sentimental things that come into play.
But if there's only one wedding band, who gets it? I've got 4 children. Who gets that?
Right. That's a great point.
So oftentimes I think parents don't want to make that decision, and they just think their kids will make that decision. You don't want to fracture a family over stuff. And to go ahead and make that decision if there is something.
I mean, and if you just can't decide who gets the wedding band, just say, look, these are the items. I can't divvy up. I'm specifying I want them sold.
Or
and then
lottery.
You will, or lottery, or either we'll pull names or we'll sell it, and then you guys can split the money from the sale of everything. There's all those options, but yeah, I can see where she's coming from. You may want to consider it. And a will in that regard is not a super expensive undertaking to do.
No.
Not at all. And I think in a way, some people think putting a will together is morbid. It's something that needs to be done, and in a way, specifying things like that, I think, especially if you're going to live still for years, it could be kind of interesting and fun to divvy it up. I'm thinking about doing that myself. Listen, we'll take a break. We'll come back with more of your phone calls if you're on hold, and Kathy and others. Our final segment with Barbara right after this.